Welcome and thanks for joining us. I'm Kristen Wintermute and I am the Director of Education. Tonight with us is our legal and policy team, and they're talking on reining in a rogue Supreme Court. With us are Lily Bolerian is the Legal and Policy Director. Stephanie Hansen is the Paralegal. Catherine McCullough is the Senior Counsel, and Isabella Russian is the Policy Coordinator for the American Humanist Association. And I will turn it over to them to begin. Thanks.
Awesome. All right, so you already met us, so we can actually go to the next one. Awesome. So reining in a rogue Supreme Court. So Kristen talked briefly about this, but just to give an overview of why we are here tonight. To most Americans, the Supreme Court was once seen as a neutral, unpolitical, independent body that was tasked with reviewing laws to ensure that they adhere to the Constitution, not legislating from the bench. We've seen recent disastrous decisions, including in Kennedy versus Bremerton and Dobbs versus Jackson Women's Health Organization, coupled with bombshell reports from ProPublica about highly unethical behavior by some of the justices on the court. And it's highlighted the danger of a rogue 6-3 conservative court. Next slide, please. So how did we get here? Well, the answer is extremely complicated. We could go back to the 80s and discuss the battle over Robert Bork. We could talk about the way that Anita Hill's sexual harassment testimony against Clarence Thomas lit up the conservative movement, led to the pursuit of revenge against liberals and liberalism. But for the purposes of this webinar, we will focus on the Roberts Court, which in my opinion will go down probably as the most partisan in US history. Going back to 2005, the first woman justice on the Supreme Court, Sandra Day O'Connor, retired, and George W. Bush nominated John Roberts to replace her. However, soon after, the oldest member of the court, Chief Justice Rehnquist, passed away. So it was at that time that President Bush made the decision to instead nominate John Roberts as Chief Justice. He was easily confirmed by the Senate. Now, for Sandra Day O'Connor's seat, it gets a little shaky. President Bush nominated Harriet Miers, White House counsel and close friend and confidant of the Bush family. She was set to replace O'Connor's seat. She was a woman, and there was bipartisan support for her nomination and confirmation. However, the far right, especially the increasingly influential Federalist Society, not like that. They did not trust Miers to be a hardline crusader. After all, Miers did some conservative no-nos like, wait for it, supporting affirmative action as president of the Texas Bar Association, and that really upset the far right. And that uproar forced Miers to drop out of consideration. So who came in instead? Instead, the Federalist Society's Samuel Alito was nominated and confirmed. Huge flex for the Federalist Society and really positioned them as super powerful on the right. And Alito, as you may recall, wrote the opinion in the case that overturned Roe versus Wade. Next slide, please. So after the Bush presidency, under the Obama presidency, much of the Supreme Court was under a 5-4 conservative majority. However, John Roberts would sometimes be a key swing vote. Obama was president for 8 years, and he nominated 3 justices as president: Elena Kagan, Sonia Sotomayor, and Merrick Garland. Only 2 of these 3 became justices. If Obama had succeeded in filling the 3 Supreme Court seats that opened during his presidency, the makeup of the court, you see, would have flipped 5-4 with a liberal majority. That's not okay to the Federalist Society and the far right. And that's when the McConnell rule was invented. After Antonin Scalia died in 2016, Senator Mitch McConnell, majority leader, invoked a non-existent rule that says presidents cannot confirm Supreme Court justices in an election year. Nowhere is this rule written. This is a completely made up rule. As I mentioned before, President Obama, within his constitutional rights, nominated Judge Merrick Garland to replace Scalia. McConnell never granted a hearing for Garland, let alone a vote, and the Supreme Court therefore shrunk to 8 seats for about a year, meaning that the right changed the size of the Supreme Court to fit their political desires. And there were nearly zero cries on the right about the horrors of packing the court. After the election of Donald Trump, Neil Gorsuch was immediately nominated and quickly confirmed to the Supreme Court, then Brett Kavanaugh. But the real kicker came in 2020, when Justice Ruth Bader Ginsburg passed away, and President Trump nominated Amy Coney Barrett, ignoring the McConnell rule that was just invented 4 years prior. And what did Mitch McConnell do? He quickly held a hearing and a vote, breaking again his rule, and Amy Coney Barrett was confirmed, solidifying a 6-3 far-right supermajority on the Supreme Court. It's so important to note that President Trump was able to fill more seats in a single term than any president since FDR. Next slide, please. So, court expansion throughout US history. So it's really important. There's a lot of talk about the size and the scope of the court, but it's important that folks understand some of the history here. The number of justices on the Supreme Court changed 6 times before getting to the present total of 9 in 1869. Then a 7th time, like I said, in 2016, when Mitch McConnell unilaterally decided to change the size of the Supreme Court to 8, simply because he couldn't allow a liberal to replace Scalia. So it's really critical to note that number 9 is totally arbitrary. There's nothing magical about that number. You will not find it in the Constitution, and you'll hear more about that later in this town hall. But I'll close out my portion of this event by just briefly discussing the most sweeping attempt at reforming the judicial system in modern US history, because I think it's really important and it'll make more sense later in the presentation. So in 1937, FDR, Franklin Delano Roosevelt, was trying to get through his New Deal. And he was facing a lot of opposition at the Supreme Court. And so he decided to attempt to oust these conservative justices who were standing in the way of progress, especially on an upcoming case related to Social Security. His main rivals in the Supreme Court were 70. So FDR's bill would have reshaped the federal judiciary by adding a new justice to the court each time another justice reached age 70 and failed to retire. So although FDR did not succeed, as he was highly popular, but he couldn't get this one through, he did outlive all 7 of those conservative justices. So just factoid to know. But his decision to act boldly and to think outside of the box to address the corruption of the Supreme Court and deliver critical social programs to the people by holding Supreme Court accountable, it informs us today, and we should really learn from history that there have been many attempts to hold the court accountable, and that we should use the tools that are at our disposal to do the same. So I'm actually going to stop here. Now that you've gotten my brief analysis and some context of how we got here, I'll turn it over to my colleague Katie to discuss some of the key decisions this compromised Supreme Court made over the summer. Thank you all very much.
Good evening, everyone. As Lily, that's a great overview, by the way, Lily. As Lily said that, my name is Katie McCarroll. I'm the senior counsel with AHA. We're going, and as she said, we're going to start by running through a few of the major decisions from the last term. First one we're starting with is Sackett versus EPA, which concerns the Clean Water Act, which landmark legislation from the 1970s, which has transformed, the rivers and lakes of our country from super polluted, catching on fire, mutant fish and all that kind of good stuff into safe bodies of water that we can drink, we can swim in, we can enjoy. This particular case concerns which wetlands are covered by the Clean Water Act. For nearly 20 years, the rule has been that any wetland that has a significant nexus to other bodies of water are covered by the Clean Water Act. And this rule stems not only from a previous Supreme Court case called Rapanos, but also from the text of the Clean Water Act itself, which explicitly says that wetlands that are quote unquote adjacent to waters of the United States are covered under the act. Well, the Sacketts, a couple who owned some property near Priest Lake in Idaho, decided that they didn't want to file for permits to fill in the wetlands on their property near Priest Lake. So they challenged this interpretation of the Clean Water Act. Jumping through some really crazy statutory interpretation hoops, Justice Alito has decided that, well, and along with, 4 other justices, that adjacent doesn't mean adjacent. Adjacent means touching or part of or having a continuous surface connection with another body of water. So this rule has basically jeopardized potentially millions of acres of wetlands that were previously covered under the act. To get to this point, the court used something called the clear statement rule. And basically, it's kind of just what it sounds like. It says that if a statute intends to interfere with traditional state powers, such as authority over land and water use, or the significant here, private property rights, because, these poor private property owners, they're just, the big bad, earth lobby is just so mean, making them have to get permits to fill in, fragile wetlands. So we can't have that. So the court significantly narrowed the meaning and the coverage of wetlands under the Clean Water Act. That pretty much does it for that one. And again, we'll take questions at the end. I'm just gonna, several of these cases are very technical and, really thick with clauses and subclauses of statute. So I'm just kind of skimming high level for now. And if anybody has any questions, we'll try to address them later on. So if we could move to the next slide. So the next case we're going to talk about is Biden versus Nebraska, which you may recall has to do with the Biden administration's student loan forgiveness program. Back in 2022, in the wake of the COVID pandemic, the Secretary of Education decided to use his powers under what's known as the HEROES Act to cancel student loan debt for a certain subset of qualifying borrowers. This power is cabined by the act to only come into play in either cases of war or a national emergency. So this is not a power that the secretary has all the time. This is a very limited power to act in an emergency. But once the emergency is triggered, the act is very, very broad in granting the secretary authority to do something to help people during said emergency. So the HEROES Act specifically states that the secretary has the power to waive or modify any provision relating to federal student loans in the event of a war or national emergency. The court decided that that just went way too far. Canceling $430 million in student loan debt exceeded the secretary's power, according to the court. Normally, the court would be bound by what's known as Chevron deference, and it refers to a Supreme Court case, decided in the 80s, I believe, early mid 80s, where the Supreme Court said that courts should defer to agencies when they have a reasonable interpretation of the statute that they are in charge of enforcing and implementing. Makes sense, especially in situations where the agency personnel have far more expertise and experience in very often scientific or technical issues that the court just simply does not have. However, the current court has ramped up use of what is called the major questions doctrine to get around Chevron deference. And so in this case, the court said that, you know, this is just too big a question. We're not going to give the agency deference. We're not going to you know, go with the clear meaning of the statute because, well, this question just has too much, you know, economic or political substance to it to allow that to happen. And so, pulling apart the statute, the court focused on the term modify as opposed to the entire phrase waive or modify, to say that the Secretary of State had exceeded his authority, and so it invalidated the Biden student loan forgiveness plan. So, one of the reasons, other than the fact that, you know, millions of people are not going to get the relief that the Biden administration tried to give them, this major questions doctrine could potentially be used to dismantle much of the administrative state. If this is too much for an agency to do on its own, then there's a lot of other things that agencies do on a daily basis that could conceivably be called into question under this doctrine. And now I'm going to turn it over to Stephanie Hansen to talk about another wonderful case, 303 Creative.
Thank you, Katie. Okay, so as Katie said, we're going to be discussing 303 Creative. This was another high-profile case that addressed Colorado's Anti-Discrimination Act. Colorado forbids refusing services based on sexual orientation for businesses that chose to sell to the public. And this case specifically was focusing on Lori Smith, and she's the owner of 303 Creative. It's a graphic and web design company. Ms. Smith planned to expand her business by creating wedding websites, but she didn't want to service same-sex couples due to her religious beliefs, and she wanted to post a message on her website to make that clear. There was no same-sex couple involved in this case compared to the Masterpiece Cake Shop, and Lori wanted to bring this case before any same-sex couples approached her. The holding of this case was that Colorado cannot force someone to create a wedding website for same-sex couples when the creative expression embodies a message with which they disagree. The rationale behind this was the court agreed with the stipulation that the website was expressive and that it was Mrs. Smith's pure speech relaying the message. This definition was key in the decision. Ultimately, it creates an exception under the First Amendment free speech provision, and that people engage in expressive activities are able to discriminate against queer people if they disagree with the message in the expressive activity. The court did not provide a definition of what counts as expressive activity, and we're expecting there to be future litigation to figure out what counts as expressive conduct. You know, is it the design of a house? Is it the food you make? Is it the hairstyle you design, etc.? There's also concerns that this will allow further justifications of discrimination under other religious beliefs and general discriminatory behavior. 303 Creative has created a major crack in LGBTQ protections, and as Justice Sotomayor stated in her dissent, quote, "The immediate symbolic effect of the decision is to mark gays and lesbians for second-class status," unquote. Next slide, please. So the day before the 303 Creative Opinion dropped, SCOTUS also released the Students for Fair Admissions, Inc. versus Presidents and Fellows of Harvard College. This case asked that the court change the law to prohibit the consideration of race in college admissions. Particularly, this case focused on the admission programs at Harvard and the University of North Carolina. So due to the pervasive inequalities in access to educational opportunities in primary and secondary education, race-conscious admissions are necessary to enable universities to identify talented students from all communities and assemble a diverse student body in order to reap the educational benefits of diversity. However, the court ruled that the admission programs at Harvard and UNC violate the Equal Protection Clause of the 14th Amendment by considering an applicant's race. Chief Justice Roberts stated in the majority opinion that students must be treated based on his or her experience as an individual, not on the basis of race. The implications of this ruling are severely damaging, as the court has now limited, if not effectively ended, the use of affirmative action in college admissions. It has rolled back decades of precedent and will force a dramatic change in how a nation's private and public universities select their students. The majority's decision left the door open for service academies like the U.S. Naval Academy, the Air Force Academy, and West Point to continue to use, at least for now, race-conscious admission programs due to, quote, the potentially distinct interests that military academies may present, unquote. However, in September, Students for Fair Admissions is back at it again and filed a case that challenged this decision on military academies. So we'll see where that goes. The court's decision has no direct impact on outreach, recruitment, affinity groups, employment, or contracting, and increases the need for diversity, equity, inclusion, and accessibility programs and critical race theory. The case also does not affect race-neutral policies governing K-12 select admission programs, but shortly after this decision, a lawsuit from parents petitioned SCOTUS to hear a case alleging the admissions process at Thomas Jefferson High School for Science and Technology, and that they racially discriminated against Asian American students. And these are all cases that we'll be keeping an eye on moving forward. And I will send it back to Katie to discuss this term's cases that we're watching.
Thank you, Stephanie. Yes, the fun rolls on. So we have a number of cases that we're watching that are coming up. The first couple that we're going to, the first one we're going to talk about on our list there is Consumer Financial Protection Bureau versus Community Financial Services Association of America, which I'm just going to refer to as payday lenders, because that's essentially what that association is a group of payday lenders who don't like a rule that the Consumer Financial Protection Bureau has promulgated against them. So they challenge the constitutionality of the entire agency. So basically, quick overview of the argument. The payday lenders are challenging, are saying that the Consumer Financial Protection Bureau, which its purpose is to enforce various federal consumer financial laws, was created after the 2008 financial crisis, and is funded in a way that these payday lenders would like to convince the court violates the Appropriations Clause of the Constitution. The Appropriations Clause states that no money shall be withdrawn from the Treasury, but in consequence of appropriations made by law. Essentially, this is a power that Congress holds. It's referred to as the power of the purse. So Congress has the power to decide where the money goes in the federal government. And it does this in various ways. Sometimes, they do an annual kind of appropriation, accounting every year for certain agencies. Others, like the CFPB, are funded through other means. So some of you are probably familiar with the Federal Reserve Board, which is funded through assessments made against banks. So the banks, the regulated industry is actually what funds the Fed, and the Fed funds the Consumer Financial Protection Bureau. So basically, the payday lenders are arguing that this is unconstitutional. And the reason that this is important and that we're flagging it is because if SCOTUS was to invalidate the funding structure of the CFPB, it would call into question not only that agency's existence, but the existence of many other agencies that we rely on every day to protect consumers, including the Federal Reserve Board itself and the FDIC, and could have just catastrophic economic consequences. And Lily, I think we talked about, I don't know whether you want to weigh in on this at this point. We talked about that.
Yeah, we did. Yeah, I would just wanted to say just a little more just about the importance of the Consumer Financial Protection Bureau. As Katie stated, that, it came after the 2008 crisis. A series of reforms were passed. One of them was the Consumer Financial Protection Bureau, and to date, it's put $17.5 billion back into the pockets of the American people. They are, they go after a lot of these companies that are doing shady practices, and it is one critical watchdog that we have and that has been slowly chipped away from, but it's critical that we maintain this, or else, the American people are really being set to the wolves.
Absolutely. Okay, so moving on to Alexander versus the South Carolina NAACP. This is a case about racial gerrymandering. So after the 2020 census, the South Carolina legislature drew up some new maps for districts within the state. And long story short, they shifted a bunch of Black folks in and out, claiming that they were doing so in order to maintain Republican holds on those districts. And you might say, well, that seems like something that they shouldn't be able to do. But oh no, in 2019, SCOTUS ruled in Rucho versus Common Cause that partisan gerrymandering, so gerrymandering for the purpose of maintaining the hold of one political party versus the other, is a non-justiciable issue under the political question doctrine, which means that courts just can't do anything about it because it's the job of the legislatures to do something about it. So we've already had the oral arguments in this one, and unfortunately, it does look like the conservative wing of the court is poised to take yet another sledgehammer to voting rights for minorities. So, hopefully that will not happen, but it doesn't look so good, y'all. Next on the list is O'Connor Radcliffe versus Garner and Linkty versus Freed. And I'm going to add into this a couple of other cases. These are First Amendment cases having to do with whether or not government officials can block citizens' comments on social media when they're using, communicating about their public positions. So, and this is important because, a lot of us, social media is how we get our news. It's how we communicate with elected officials. There was a similar case that, concerning then President Trump that went up to the Supreme Court, but ultimately was mooted because Trump was no longer president. So, luckily the Supreme Court is pretty strongly in favor of preserving First Amendment rights. So hopefully that will continue. However, I think there's probably a lot of nuances and ambiguities concerning how some of these public officials use their Facebook page or their Twitter feed, a mix of public and private or personal information. So that one will be interesting to watch. And another pair of First Amendment cases, which are also worth noting, have to do with whether or not states can regulate social media companies and prevent them from taking down or deplatforming ideas that they find objectionable. And Florida and Texas have both attempted to pass laws like this. The Florida law got mostly thrown out. The Texas law did not. So this is a classic circuit split, which is one of the reasons that the court has decided to take it. And this would be interesting if the court sided with the states as opposed to social media companies. It would turn a large part of First Amendment jurisprudence on its head and would have significant implications for media, even traditional media outlets like newspapers and things like that. Now I'm going to turn it back over to Stephanie to talk about US versus Rahimi.
Thank you. So yeah, this is another, potential case that has major implications. It's US versus Rahimi. Rahimi was convicted of possessing a gun while subject to a domestic violence protection order, and is challenging that the prohibition of firearms is a violation of his Second Amendment rights. This case is coming from the U.S. Court of Appeals Fifth Circuit, which invalidated the law on its face, and they agreed with Rahimi, stating that individuals subject to domestic violence protective orders have a constitutional right to still possess guns. Many are obviously urging SCOTUS to reject the Fifth Circuit's reasoning, and that imposing time-limited firearm restrictions based on restraining orders is a critical tool for protecting those that have experienced domestic violence and face a threat of further violence. Depending on the decision, it could, influence other federal prohibitions on gun possession, including those that apply to those convicted of a felony, and raises further constitutional questions under the Second Amendment. If the Supreme Court overturns this law, we would likely see an increase in domestic gun violence and put the lives, especially the lives of women, at risk. And this one is scheduled for oral arguments on November 7th. So we'll be watching that one and see if we can't get an idea of which way we think the court is going to lean in this ruling. So I will send it back to Katie for the last case.
Thanks, Stephanie. Yes, last one, and then we'll move on to what can we do about all this nonsense. So the last case, which is actually a pair of cases now, Loper Bright Enterprises versus Raimondo and Relentless Inc. versus Department of Commerce. And these are nearly identical cases, except that Justice Ketanji Brown Jackson is recused herself from the first one and not from the second one. So which will be significant, considering that this is another case where the Chevron deference doctrine is being called into question. Just to boil it down to brass tacks, this has to do with a fisheries conservation and management regulation that requires vessels to carry and pay for the services of an observer to make sure that the vessels are complying with conservation and reporting requirements. Some industries are challenging this as unconstitutional and over broad, and are asking the court to overrule Chevron, so that courts no longer defer to government agencies when they promulgate regulations and interpretations of the statutes which they administer. And, you know, as I mentioned before, with the with some of the cases from last term, this could be potentially catastrophic, because it, you know, with this kind of court, it could lead to the complete dismantling of the administrative state. And so government as we know it would no longer function. So since we have a lot of other stuff to cover, and I want to make sure we have time for questions, I'm going to leave it at that. And so I think it's time to turn it over to Isabella, if that's correct.
Yeah, thank you so much, Katie. All right, so after all of that wonderful and uplifting information that we just heard, let's transition into talking about the legislative solutions that are being fought for in Congress that aim to address the imbalance in the court. Once again, my name is Isabella. My pronouns are she, her, and I'm the policy coordinator at the American Humanist Association. Today, we're going to be briefly discussing the Supreme Court Ethics, Recusal, and Transparency Act, or SCIRT, or SCIRT as it's referred to, and the Judiciary Act. We'll also be making some suggestions of some direct actions you yourself may take to combat this rogue court. I know that there was a question in the chat, so we're going to be talking a little bit about that. So as Katie, Lily, and Stephanie mentioned, the court cannot be regarded as reliable in its purpose. The current court majority has aligned itself with the political far right, overturning decades-old precedent, ignoring bedrock constitutional principles, and legally codifying an extremist worldview. The invalidation of over 50 years of precedent with regards to federal abortion protections via the Dobbs decision in June 2022 cleared up any doubt about the destructive intentions of the conservatives on the Supreme Court. As was mentioned, other recent devastating decisions have gutted affirmative action, legalized more explicit discrimination against LGBTQIA+ individuals, and decimated student debt relief. At the same time, several justices have been accused of ethical violations while serving that call their objectivity and fairness into serious question. As a result, public confidence in the court has plummeted, and the court is increasingly viewed as a partisan institution rather than a fair-minded arbiter of issues and an even-handed defender of constitutional rights. According to a recent Gallup poll from September 29th, 41% of Americans approve of the Supreme Court's job performance, which is close to the 40% record low, and 49% have trust and confidence in the Supreme Court, which is near the 47% historic low. I personally am very tired of a rogue court being able to dictate who my friends can love, who can force me to have a kid, and what tenets of some religion I must adhere to, in order to fight off the fascism that Christian nationalists steadily work to implement. We advocate where we can, at least at the national level, to pass legislation that institutes ethical safeguards and restores trust in this important and powerful part of our government. Because truly, the need to transform the judiciary could not be more critical or timely to our fledgling democracy. Next slide, please. So the first piece of legislation we'll talk about is called the Judiciary Act. The Judiciary Act of 2023 is sponsored by Congressional Free Thought Caucus member Representative Hank Johnson in the House and Senator Markey in the Senate. And it's actually quite a simple piece of legislation in that it only has one single provision. This bill simply increases the number of SCOTUS seats from the current 9 to 13, of which the 13 accounts for the 13 federal circuit courts that we have here in the United States. Why is the Judiciary Act, I always have difficulty saying that word. Why is the Judiciary Act important to support? Well, the takeover of the High Court has caused a significant breakdown in trust in the judiciary, and for good reason. And the consequences of the decisions of a reactionary Supreme Court will effectively block progress for generations. The only way to stop the agenda of the Christian nationalists with a grip on the Supreme Court is to remove them from the majority. Unfortunately, regardless of any future progress, any law that would positively impact the issues that matter to humanists will almost certainly fail to get past a 6-3 majority for generations. And it's for this reason that Congress must act expeditiously to expand the Supreme Court to 13 seats. Now, you may have heard some criticism of expansion, like saying it's like extreme or unprecedented, but that is just simply not true. Historically, the number of seats on the Supreme Court has been adjusted 7 times over the course of our nation's history, as Lily mentioned before. And indeed, there is no constitutional mandate on the number of justices on the High Court. Congress has the right to make this change as it sees fit. No, the specific policy goal, court expansion, is certainly not as unpopular as many would have you think, and we're definitely not the only organization calling for expansion. The American Humanist Association is proud to join the broad and growing coalition of organizations calling for explicit expansion, with groups that include the Just Majority Coalition, American Atheists, Planned Parenthood, Demand Justice, Public Citizen, the Freedom from Religion Foundation, United for Democracy, the Unrig the Courts Coalition. I could go on, and so many more. And in addition, as each day goes by, the Judiciary Act steadily gains more co-sponsors, thanks in part to people like you who reach out to your members and urge them to do so. So support and need for the Judiciary Act is there, and it is indeed a very important bill to pass. Next slide, please. Okay, moving on to the Supreme Court Ethics Recusal and Transparency Act. So we as humanists are very well aware that the legitimacy of our democracy rests upon the transparency of our government and the integrity of our judicial system. Recent questions regarding the ethical practices of SCOTUS have contributed to this erosion of public trust in the justices' neutrality. There's justified concerns that cases, particularly ones pivotal to the state of human rights and civil liberties, will not be decided in an impartial manner. Amazingly, unlike all other federal judges, SCOTUS justices are not subject to a formal code of ethical conduct. This hinders the ability for full transparency, accountability, and fairness in one of our nation's most important and powerful institutions. We understand that democratic institutions should function within the standards of transparency and ethics, and that federal judges should be making decisions which affect the lives and civil liberties of our communities in an independent, impartial, nonpartisan, and informed manner, and in a way that meets the needs of all Americans, including secular Americans. So the Supreme Court Ethics Recusal and Transparency Act, or SCIRT, addresses this in a myriad of ways. First, it would establish a code of conduct for SCOTUS justices and federal judges, as well as institute gift, reimbursement, and income disclosure requirements for SCOTUS. The bill would require recusal under specified circumstances, such as if a party to a proceeding lobbied or spent substantial funds to get a judge or justice confirmed. This legislation imposes on justices and judges a duty to know their and their family's financial interests that may be substantially affected by a case, and a duty to notify parties of a proceeding of conditions that could require disqualification. The bill also establishes review panels for consideration of motions to disqualify, and it makes a lot of other important changes as well. SCIRT in particular has a beautiful track record in Congress in the fight for its passage. Last year's version of the bill passed the House Judiciary Committee with resounding support, and this year it passed the Senate Judiciary Committee, of which it now awaits a hopeful floor vote. And SCIRT is, of course, not only well supported by members of Congress, but by members of civil society as well. Last slide, please. Okay, so now that you are aware of the few policy actions backed by congressional reform champions and civil society, it's imperative that you ask yourself what it is that you can be doing to act. Sure, we can talk about bill provisions and legal language all we want, but you may be asking what advocacy for the advancement of a piece of legislation actually looks like. So we in the policy team at the American Humanist Association work hard to push the needle further on these court reform bills. And we do this in a myriad of ways, one of which includes lobbying. Lobbying entails building relationships with House and Senate staff, creating materials that analyze and more easily explain legalese, and making meetings to provide insight into the humanist perspective and position on why a bill should or should not pass. Additionally, we coordinate and work with like-minded coalitions to fortify the amplification of legislation and provide support to initiatives aimed at achieving our policy goal. Almost not unexpectedly, since a very partisan Supreme Court continues to roll back progress from reproductive rights to the environment to democratic processes, the list of partners fighting for court reform from all different issue areas is steadily growing. Coalition building is important because, one, each organization has their own members, contacts, and relationships that can be leveraged to achieve a goal. Two, organizations can provide expertise and historical context in their area of focus. And three, the capacity to take actions, such as setting up petitions, targeting certain geographic areas, organizing, creating resources, is increased past what just one organization can take on. So for example, AHA is currently helping the organization Stand Up America with their effort to collect signatures on a petition that calls on Congress to take certain actions to uplift the ethics and transparency of the court. Another example of how we work on getting legislation passed is by engaging our own members and creating resources that keep you informed. This webinar is, of course, one such example, but we also try to be diligent in creating action alerts for priority legislation. Action alerts, which are found on our website within the Humanist Action headquarters, are a very quick, easy, and effective method to advocate for legislation that matters most to humanists. These often just resemble emails about bills that make it simple for you to review and send. They only take a second to fill out, and they actually make a huge difference, because when a congressional office is contacted by a constituent on a matter of legislation in this way, the opinion is heeded and considered by the office. And I think that this might sometimes be forgotten, or maybe it seems obvious, but representatives and senators are there to represent your wants and needs, and they need to hear what you have to say. So now, as an informed humanist and/or person, I ask that you ask yourself how you can use this information you've learned today to make a difference on the topic of court reform. As I've just stated, take a moment to visit our Humanist Action headquarters and reach out to your elected officials in Congress. But action alerts shouldn't be your only means of contacting them either. As a constituent, make a difference by calling their office, even setting up meetings with them to talk about why a piece of legislation or a policy goal matters to you and how it affects you. I'll tell you specifically that congressional offices are often eager to meet specifically with constituents, and you shouldn't be shy, because in my experience, congressional staff are very friendly. Another great way to advocate for the issues that matter most to you is to volunteer with like-minded groups and coalitions. Civil society organizations often have the resources, the connections, and the expertise to hold informational events, help you build relationships, teach you the basics, point you in the right direction, and support you in your advocacy endeavors. Perhaps pick 2 or 3 organizations you believe in on topics you care about, and of course, encourage your friends and family to do the same. In line with this, frankly, a great and effective way to ensure our democracy doesn't backslide into oblivion is to donate what you can to orgs like us. Financially backing us as we do the work to liberate our court and fight for progressive humanist values in civil and human rights is definitely a very great way for you to contribute, especially if you are a busy person with little time to dedicate to other advocacy measures. And I just want to close with finally, there's just one action you can do that is perhaps the most important of all time. Please, for the love of humanity, vote. Please vote. Please make sure that your registration is up to date, and check in with your friends and family and community to ensure that they too are registered in voting. You know, I can't tell you who to vote for, but I can encourage you to vote. I will tell you that any progress we make as an organization, as a community, as a country cannot be guaranteed, nor can it thrive if our elected officials are bought and sold, if they don't care about civil and human rights, about the environment, about the separation of church and state. And if you don't vote, I'm sorry to say that none of this matters. And on that happy note, I'm happy to wrap it up and turn it back over to Lily. Thank you so much.
All right. Awesome. Thank you so much. So I think actually I am handing it over to Kristen for
Yeah.
Q&A actually.
Before we take some questions, Lily, do you want to mention a little something about, I see in the chat people are commenting about separation of church and state, and Nicole made a comment in the chat. She's our interim executive director about our focus does remain. We continue to do that. Do you want to say a little bit more about maybe some of the things that in relation to that, just because it came up in the chat?
Absolutely. Yeah, absolutely. Yes. So our focus remains on separation of church and state. We are involved in active litigation on these issues. That's not going to change. But we are well aware that the Supreme Court is going to stop us every time we try to achieve a humanist bill or any kind of bill that would protect our values. And so that's why we, and as our Nicole mentioned in the chat, FFRF and some of our other groups in this space, we have focused now so much on court reform because our court has been overtaken by Christian nationalists, and that is a fundamental separation of church and state issue and an absolute crisis. So rest assured that we are absolutely fighting those issues, but we are also humanists, and we're part of a greater progressive movement, and we believe all of our issues are connected. And so, you know, we are excited to jump in where we can to provide our expertise, which is very much the Establishment Clause, First Amendment, and separation of church and state.
Thank you so much. Thank you, everyone. What a great job. And it was really fun to listen to and hear more about all the cases. I do have a question. Are there any cases that could put any Social Security programs at risk? If yes, which programs?
I'll happy to jump in
Sure, go.
if you like. So the cases that I talked about having to do with Chevron deference and the major questions doctrine, as well as the Consumer Financial Protection Bureau case, these are all cases that could potentially endanger any number of social safety net statutes that are out there. They wouldn't have an immediate effect. These cases that were discussed tonight would not have an immediate effect on any of those safety net statutes, but it would set dangerous precedent that would put them potentially on the chopping block because of the way that this court views the administrative state. I hope that answers the question.
Yeah, thank you, Katie. Another question, I read that Clarence Thomas wants to get rid of access to contraceptives. I'm not sure if that means a ban or just making it more difficult to get them. Are there any cases on the schedule that could put contraceptives at risk based on how the court rules?
So I'll take a stab at this one. So there's not, to my knowledge, a direct contraception case before the court. But I want to be clear that all of the attacks you see on abortion are also attacks on contraception. So they're starting with abortion because that's like the red meat. That's easier to say. It's harder to say you're going for contraception. But fundamentally, that is absolutely what they are doing. And so, you know, right now, one of the major things that we are watching is to see what the Supreme Court does with mifepristone, which is the abortion pill. I think that, you know, we're not looking at really great. It's not looking good. It's looking really kind of scary. And so I think that'll give us an indicator of where they're headed. But at this direct time, there's not a current active case, to my knowledge, that challenges contraception. But I would definitely keep your eye on all of the abortion related cases because they're directly connected.
And just to add to that, Lily, the Fifth Circuit mifepristone case, there has been a cert petition filed with SCOTUS. They have not ruled one way or another on it. So it is possible that they will pick up a case having to do with that this term that we just don't know yet.
Can you all address what other organizations we're partnering with on cases? Maybe give a little more information to people.
Legal cases?
Yeah.
Awesome. I'll defer to Katie on that one.
Sure. Well, we We do have one ongoing case right now in Arkansas that concerns a Ten Commandment monument on the State House grounds, and we are partnered with Freedom from Religion Foundation on that one. The ACLU is also involved with another set of plaintiffs, but we are essentially kind of co-counsel with FFRF with one group of plaintiffs in that case. We also have recently done work with American Atheists involving a free speech claim for atheists in Fort Worth, Texas. Let's see. That is most of what I can think of off the top of my, am I missing anybody, Stephanie, that you can think of?
I have another question. I think this will be the last one, and then we'll wrap up unless other people want to make some questions in the Q&A. For those who believe any press is good, are there cases humanists should try to bring to the court for attention, even if we can't win?
Yeah, I don't know if you want to take a stab at that one. I would say that the legal environment right now, the judicial system right now is precarious. That is the best term I could think of. And I'll let Katie speak deeper to it because she's actually involved currently in litigation and she can speak to it.
Absolutely. Precarious is a great word for it. I think that the danger with bringing any kind of suit simply to raise awareness is that if we lose, we create bad law and we make things worse for humanists, atheists, freethinkers, you know, throughout the country. And that is something we definitely do not want to do. So we are thinking long and hard about any potential litigation and what the potential real world backlash could be if we lose, because we don't want to get a little bit of publicity at the, you know, expense of people's rights. It's just not worth it. So we are being very careful that we are protective of the rights that we have now first. And we are trying to be very strategic about where we can go in the legal minefield right now.
So if I can just jump in really quick to address, of course, we're saying that, you know, court reform is very important, and supporting the Judiciary Act and the Supreme Court Ethics, Recusal, and Transparency Act are a very important piece of that puzzle. But just to address some of the comments in regard to what the AHA focuses on, I do want to mention that we do also work hard to support other pieces of legislation, such as the Do No Harm Act, which clarifies that the Religious Freedom Restoration Act is intended to protect religious freedom without allowing the infliction of harm on other people. We work every year to introduce the National Day of Reason resolution. And last year we supported the Health Share Transparency Act. It has not been introduced into this Congress. However, that was also another pretty strict separation of church and state issue. It would basically protect people from the deceptive practices by healthcare sharing ministries, which are a whole another thing. So those are just a few of the examples. Of course, the beauty, I think, of humanism is that we are able to address a lot of issues that are related to the separation of church and state, such as, you know, abortion, contraception, LGBTQIA plus rights, the environment. But those are just some examples, and I hope it was helpful to provide a little overview of some of the other work that we're doing.
Yes, thank you. Because I think there was a lot in the chat about why we're focusing on this tonight. And I think you answered those questions and addressed the other work that we continue to do that is also a part of our, but we're expanding our focus and keeping an eye on things for the benefit of humanists. I just want to thank everybody for coming tonight. I want to thank our panelists, our legal team, our legal and policy team. Thank you for such a great job and informing us about what's up with SCOTUS. For more information on what we do, visit theamericanhumanist.org for our events, to become a member, find a local humanist group, and to support our work like Isabella asked. Previous programs and resources are available at theamericanhumanist.org and at the American Humanist Center for Education.org. And I just want to thank everyone tonight for joining us. Much appreciated.